Olivia, can you give us an understanding in relation to what domestic building works are, first of all?
Domestic building works include renovations, erection of a new home, demolition of a house, pools, landscaping, also drawings. The list goes on.
So it's a quite wide range of things that comes under this legislation.
Is there a value put on what would be a major domestic building work?
Comes back to anything over the value of $5,000. That's the key tipping point. Under $5,000, and that includes labour and materials, under $5,000 means that you can get a handyman to do those works.
Do you think it's a good idea to still have a contract in those situations?
Oh, absolutely. Yeah, it's an imperative. To proceed without one, well, you're asking for a lot of trouble.
Most building disputes happen because details weren't documented or the terms of the contract weren't understood by both parties. Variations weren't put in writing, and the actual works weren't described the way that each party thought.
So if there is a dispute, how do we resolve?
I think one of the most important things to recognise is when you're entering into a contract is to get good advice, both legal advice but also from an industry expert, someone that can assist you with information at the outset, making sure that your interests are protected, because the builder's certainly going to look after his interest.
And how do we resolve the dispute, or if we have one?
Well, I find that working with the builder is really an imperative. I do a lot of work with builders, not just with owners, making sure that people understand how to work through challenges. It's inevitable in a relationship that you're going to have, in all relationships, you're going to have challenges along the way. It's how we deal with those challenges that makes the difference.
What are the sort of most common conflicts or disputes that people come across in relation to these matters?
I would have to say defects and delays. The problem there is with defective works. Builders who are trying to make a living, earn an extra dollar here and there, want to get the job, so they underquote the works. And then what happens there? They try and cut corners with the work, which results in defects. Delays, usually the builder runs over time, which in turn results in the owner having to pay extra rent, loses time and
Does the owner have any repercussions if it is delayed?
Oh, certainly. Again, under the terms of a contract, there is specified times, and the builder is required to complete the project in that time that's stated. There are circumstances where the builder can have that time extended, typically weather delays, which are again identified through the contract process. The other thing which is a bit of a trap for some people is variations. Now, variations occur when documentation may not have included all of the right specification, so the builder can slip in a variation. It's important to make sure that you get a copy of that variation, you read it very carefully before you sign it, and they should always be signed. That's an important aspect of getting it right. The thing to check for, though, is often the builder will add additional time to the variation.
That's a quite important point, isn't it?
My word, it is. Yeah, when we see the builder, for example, might add 10 days for adding an extra PowerPoint, we might be a bit concerned about that.
Of course. Now, talking about variations, in certain situations, of course, you change your mind and you decide to go for a variation. But before you start the building project, I guess it's quite important to think hard about the things that you want to do and sort it out at that level.
You can certainly save yourself a lot of time, pain, and a whole lot of mucking about if you can sit down and thoroughly go through your specifications before you start finalising your contract.
Now,
get the detail right. The devil's in the detail.
Of course. You mentioned about defects. What is a major defect?
A major defect typically is something that might affect the structural aspect of a building. So it could be something like significant cracking, and we have ways to categorise this. It needs to be a category 4, which is quite a large crack, around 15 mil, for example, and that would require a wall to be taken down and rebuilt. So it's a substantial defect as such. It could also be a combination, a number of cracking in a wall, as an example.
Now, we did touch on the subject how to resolve a dispute. Of course, the first point would be to talk with the builder. If it is not resolved, Olivia or Phil, where should we go? How should we deal?
The way that you would settle building disputes, and usually I'll use the example of a owner and builder having the issue of defects. I would advise my client to engage a building expert to work with the builder and have those defects rectified. Another way of resolving the building dispute, and it's not so much resolving it, but to ensure that your contract protects you. So if there are delays, you've got liquidated damages, so you can take those damages out of the final payment if the builder is late. Now, liquidated damages, for example, are if the builder is late, say 4 weeks, and you've allowed $500 per week for each week that the builder is delayed as liquidated damages, you're entitled in most contracts to take that sum out.
I see. So this is mentioned in the contract, is it?
Usually.
I think it's important to recognise here that it's a very common trap where people settle for the default clause, which is $250 a week, which is a standard default in our contracts. Now, I don't know too many places that you could possibly rent for $250 a week. So that was okay back when these were introduced back in the 80s. However, today you need to sit down and discuss with the builder what is a realistic price if you're not able to get into your house in that certain time that's set.